Legal analysis on the implications of what this statement actually have on the outcomes of this matter. And we are joined by legal expert, attorney Kumisa Khanari. Good to have you, and thank you very much for your time and coming on tonight here on In Focus. Firstly, a witness says, I would have written a statement, handwritten one, and initialed every page, and it was later typed. And the defense are saying, well, you are hiding this statement from us, at least saying the prosecutor is hiding this statement from us. How serious is a charge of hiding, I suppose, a statement that would have been handwritten and only disclosing one?
Yes, good evening, Tabo. I mean, it's just an assumption, really, that a statement, is been hidden from the defense. And we have it on record that, such a statement does not exist. If at all it did, then, it has been destroyed. And what we have is, this statement that is typed that's now in court, which would be evidence now that, will have to be relied on and also, cross-checked and or examined by the defense.
So whether or not the witness is now in the typed statement adding stuff that were not mentioned in the handwritten statement is neither here nor there.
Yeah, sure. I mean, for as long as there's no contradictions and what you would call, perjury, evidence can always be introduced, at least to the extent that it does not prejudice the other parties being the accused in this process. But at the end of the day, it's a call that has to be made by His Lordship Mokgwatleng. I mean, he's tasked with a very huge job of managing these legal proceedings, and unfortunately, the responsibility of hearing and deciding on such disputes, rests with him, and he cannot shift it to anyone else.
Yeah. Under normal circumstances, suppose in the course of duty as an attorney carrying out your work, would it be required of you, or would it be something that you consider prudent to have both statements in the docket and actually have them both submitted?
Yeah, sure. No, definitely. Because remember, the statement would also form part of, the body of evidence that you would want to consider. And that also prepares you as a legal representative, especially on the defense side of things, how to approach evidence that has been put forward by witnesses brought by the state. So it's always to have recourse to everything and all documentary evidence and other sort of evidence that exists, so that you are in a better off position to prepare and also see if really that evidence has been used in a way that proves the state's case beyond a reasonable doubt. Because if it doesn't, then you don't even have to go into the leg of having to call your clients and being the accused persons in this instance to come and testify. You can just at that point say you don't need to call them because the state failed to prove their case beyond a reasonable doubt, and as a result you request a section 174 where you get absolution from the instance without having to argue your case as the defense.
Yeah. If I'm writing notes, suppose I'm writing notes for myself, and it does seem in this particular case there would have been notes written in some piece of paper, and now they are lost. What is the legality and the lawfulness, I suppose, of those notes in the matter, and should I be forced to disclose? Because Baloyi is arguing that her client, or at least the witness, should not be subjected to disclosure of his notes.
Yeah, I mean, why would you not want to disclose something that is so directly linked to, the main issue? That's why even police officials or investigating officers would have a record book that they use in their daily, jobs to record what they have done at what time and how they did it. And that becomes very helpful when we get to the stage, to a stage like this where we have to argue now, prosecution and defense. So we understand, there may be differences in terms of evidence that is considered by a judge in a particular matter. For instance, a statement which would be, a statement under oath, if you may, an affidavit, would be one part of, this body of evidence that you would want to consider in a process like this. Notes are also very important. They are also evidence, and they also assist, the presiding officer in trying to resolve the dispute, either an interlocutory one like we have been dealing with this issue now, or a bigger issue and not really a case within a case, where a dispute would have to be resolved by making a finding of facts and also applying the appropriate law in a fair hearing. And I mean, audi and an opportunity to respond to such things becomes very important.
And finally, would this particular matter of the notes, even though the court has found now on record that there are no such written, there's no such written statement that exists anywhere, but can this matter be brought back by the defense at the later stage to say, well, there is a dispute in this particular matter as far as what was said to us was in that written statement compared to what is the typed statement?
Yeah, sure. I mean, look, the problem is the case needs to move. And as a result, your Lordship Mokgwatleng has to chip in and really decide, and speedily so. I mean, he has to decide how these proceedings unfold. And as the defense, if you allege something and you cannot back it up with evidence, it becomes a bit problematic to even convince the judge that you need to have a look at this issue because of this evidence that we are bringing about the notes and or the statement that we do not have here. We understand that as an accused person, you don't have to prove your innocence, but it is the state that has to prove your guilt beyond a reasonable doubt. So it becomes that balancing act that needs to happen, and even though you are not the onus is not on you to prove your innocence, but at least where you make allegations or accusations, at least support those by way of evidence, be it documentary, be it by calling a witness to come and testify on that point in question. Do something that will assist the judge to find in your favor.
Appreciate your time. Thank you very much for coming on. That's Attorney Kumizi Kanari there, helping us with some analysis on the outcomes of what took place today in the Senzo Meyiwa murder trial.